That was my foolishness. And we were caught in a snowstorm, and I found myself in upstate New York in a place called Batavia. And I thought, Batavia? What am I doing in Batavia, in upstate New York? Because Batavia, of course, was also the name given to this other place that we see on the map, which is the city that we now know as Jakarta. And of course, Batavia has all these historical associations with Holland and the Netherlands. And so we can see the extraordinary network that was created, and we can see the, well, Cape Town on the map. And that was, you know, I guess, I suppose the European settlement of this particular area was as a result of the activities of the Dutch East India Company. And we can see it was a post on the way to Ceylon and the East Indies. And also, of course, it was very important, I think, to use the trade winds to travel towards Australia, but if you did not take a left turn, you would crash into Australia. And that is what happened to a vessel in 1629 called the Batavia. It was the leading ship of the Dutch East India Company in 1629. And there was a wreck off the coast of Western Australia. I suppose it is a journey that has been made in somewhat more a somewhat smoother fashion in more recent times. I think Perth has a number of South African residents now. So I suppose there is that, it's a smoother journey on the whole, even if people complain about the 14-hour flight or whatever it is from South Africa to Perth. It was an extraordinary network, and I can't make the argument here, but I would almost claim it was the Dutch East India Company that created the modern world of globalization. That's a rather extravagant claim, but it's something that I would perhaps at least attempt to develop in other circumstances. And in terms of the wealth of the Dutch East India Company, we can see, this is Forbes magazine. And this is the wealth of the Dutch East, and of course they adjust for time and all the rest of it, all those complicated things that I don't quite understand. But the claim is that the Dutch East India Company was worth something like $7 trillion at the height of its value. Apple has some way to go, as we can see. It was an extraordinary type of entity. And what is extraordinary about this entity, of course, is that in addition to all this, it created new forms of financing. I believe that the first stock exchange was created in Amsterdam to enable trading in shares of the Dutch East India Company. So it was a different type of technology. It was a legal technology that was authored by a genius. And so the problem, going back to the capture of the vessel, was there's going to be a legal argument about it. We need a really good lawyer to represent the Dutch East India Company. And that young, brilliant genius of Holland is somebody that I think all of you would be familiar with. His name was Hugo Proteus. He was the lawyer of the Dutch East India Company. Now the interesting thing about Grotius is, and I've learned now after arriving here that I should pronounce his name Grotius, not Grotius. The interesting thing about Grotius is that in the West he is seen as being the scholar whose great work, The Rights of War and Peace, published in 1625, provided the theoretical foundation for what was later to be the Peace of Westphalia. Grotius is understood in those circumstances. There's a Western Grotius, the author of The Rights of War and Peace. But if we look at a different event, we can see that perhaps there is another Grotius, the Grotius of the Dutch East India Company. And in fact, it was his relationship with the Dutch East India Company that endured throughout his career. He had a very, let us say, haphazard political career. Some of you might know of the story of how he was almost executed. He had to escape a castle in Holland, and he escaped from that castle by hiding in his own book box. So he had a huge box in which books were supposed to be transported to him when he was in prison. He hid in that box and escaped. But it was his relationship with the Dutch East India Company that was the most enduring link professionally of his life. He was regarded as such a brilliant scholar in this regard that Cardinal Richelieu of France, Three Musketeers, the bad guy, Cardinal Richelieu wanted to hire Grotius to ask Proteus to devise something like a French East India Company, because what we were looking for was a legal technology. Okay, now what are the circumstances of, can we decolonize Proteus? Rather than seeing him as the great scholar who produced the theory of Westphalia, is it possible to see him instead as being the scholar who provides corporations with the legal framework that would enable the creation of this massive trading empire? And then, could we say international law is not so much about states, it is about corporations. And it is possibly the case that Grotius, and I'm not being very scholarly here, I'm just throwing out ideas because I suppose that seems to be the way in which I find myself engaging with audiences, because I think it's important to sort of expand the range of ideas we consider. But could we possibly see then international law as being about creating a system that would protect property and provide the foundation for trade? Because Westphalia is supposed to be about the principle that a sovereign state has absolute authority within its own territory. That's a classic idea of Westphalian sovereignty. But Grotius claims, as a result of 1603 and those events, that trade is such a fundamental right that no sovereign state can actually prohibit trade unless there was real harm or damage or injury suffered by the people in whose country the trade was taking place. Trade became something like a universal principle. So can we see international law in a different way then? It is all about trade, it is about corporations. Now there's a great deal of controversy now about whether corporations should be held accountable for human rights violations. And people regard corporations and make the argument that corporations are now like states and that therefore corporations should be asked to comply with human rights standards. This is thought to be a new argument, but in fact it's a very old issue because we can see that corporations were sovereign. And here in the Cape, surely there can be no question about it, because I would imagine it was the Dutch East India Company that administered the governance of this colony, just as it administered the governance of Sri Lanka, or Ceylon at that time. Corporations were sovereign, and it is history that reveals that. And this perhaps opens up another set of issues that we could see as being central in terms of a theory of international law issues that we are only now beginning to gradually engage with. International law is about the protection of property, it is about trade, it is about corporations, as opposed to being about states and simply war and peace, although there is a complex relationship between trade and war and peace. So this is simply to go back to Professor Beinart's suggestion that we look at history, but also to say how history generates theory, the questions that are thought to be the most important. Now the interesting thing is that Grotius was asked to provide an opinion to the Dutch East India Company, and he did, and the name of the book or the pamphlet that he produced is called The Free Sea. But he wrote a much larger book called The Rights of Prize and Booty, and it is possible that even his great text of 1625 and all the issues about legal personality, about property, about war and peace, all those issues were initially thought of in the context of the rights of the Dutch East India Company. And it was later that those concepts were transferred to his great book, The Rights of War and Peace. Now, here, I haven't done all the scholarship that is necessary to make this claim, but I'm trying to suggest a set of arguments that might be plausible. So if that is the case, we should see international law as beginning not in the West, but off the coast of Singapore. That is the event that we might focus on in these circumstances. And then we have to start thinking, for the first time, let me mention the word about imperialism. Because the classic model of Westphalian sovereignty does not really enable us to think about the issue of imperialism. Where does imperialism fit into that picture? If the problem is, how is order created among equal and sovereign states? Why is imperialism left out of that theoretical model? It is left out of that theoretical model because the problem or the challenge for colonies is that they were never sovereign. So can we see how a theoretical construct which focuses on the existence of equal and sovereign states cannot take into account the history, the experience of the countries that were lacking in sovereignty? And the important question we have to ask is, well, why were they lacking in sovereignty? So let me now shift yet again, I hope it doesn't get too confusing, to another historical event. So let me claim that international law begins not in 1648, perhaps it begins in 1603, or perhaps it begins with this event in this portrait, and this is actually, I think, something that all of you would be familiar with. This is the arrival of Columbus in the New World. So perhaps international law begins in 1492. Let me try and make that claim when the issue of imperialism becomes, oh dear, now it's switched off. I need to be rescued. I should be better at this by now, isn't it? For me, the importance of 1492 is that it makes an imperial encounter the foundation, the model from which we might be able to actually generate a theory. Can we see the issue? And so, this is a rather stylized, idealized way in which, of course, Columbus and the West saw this encounter. You know, the Indians are sufficiently awed and respectful. They're already worshipping the cross. And they look forward to becoming civilized, no doubt, by this whole encounter. But let me actually use the words of Columbus himself to try and illustrate how this encounter was conceptualized by the West, at least. So here is this is the English introduction of, English translation of Columbus's account of his arrival in the New World. And that account is written in Spanish. Sir, and so this is the translation. Sir, as I know that you will be pleased at the great victory with which our Lord has crowned my voyage, I write this to you from which you learn how in 33 days I passed the Canary Islands to the Indies with the fleet of the most illustrious king and queen our sovereigns gave to me. And there I found very many islands filled with people innumerable. And of them all I have taken possession for their highnesses by proclamation made and with royal standard unfurled. And no opposition was offered to me. To the first island which I found, I gave the name San Salvador in remembrance of the Divine Majesty who has marvelously bestowed all this. The Indians call it Guanahani. To the second, I gave the name Isla de Santa Maria de Concepcion. To the third, Fernandina. To the fourth, Isabella. To the fifth, Isla Guana. And so to each one, I gave a new name. I use this example quite often when I'm asked to discuss these issues about imperialism, because I really can't do any better than this. These are the words of Columbus himself about this encounter. So let's have a look at those words. So it's rather strange, isn't it? The first thing is, he doesn't know where he is. He thinks he's in the East Indies, and that's why we still have the term, West Indies. But he thinks he's in the East Indies, but he's not. But of course, that doesn't deter him in any way. The first sentence is rather ritualistic and rather effusive acknowledgement of the genius and brilliance of His Majesties, and we're all familiar with this, isn't it? You've got to be duly appreciative of your supporters and financiers, so he does all that. But the first thing he tries to do is, he tries to take possession. And there I found very many islands filled with people innumerable, and of them all have taken possession. It's a rather interesting way in which to behave, isn't it? To go to a foreign country. It's like me coming to Cape Town and said, well, good to see you all, and of you all, I am taking possession. But we can see a few things here. We can see that it is a legal act, possession. And Columbus is no lawyer, but he realizes that he has to establish title. Can we see that issue? And how does he do it? And we can see the picture. And with royal standard unfurled. You can see the royal standards unfurled and all the rest of it. But we can see that there's a fundamental legal problem that conflict of law scholars among ourselves and even plain common sense would suggest. What is the law that governs relations between Columbus and this entirely new entity? Can you see the issue? how do we construct a law? Because surely law, to be legitimate, is something that all parties should consent to if they are to be bound by it, correct? So this is a problem for Columbus. It's like me, as I said, coming and taking possession here. And can we see how he tries to resolve it? He doesn't know where he is, he doesn't know what the islands are, he doesn't know who these people are, that there are lots of them, but his instinct is to take possession. And then can we see how he tries to do it? And no opposition was offered to me. In other words, it is the old idea of silence is consent. They agreed to it. That is why they should be bound by these circumstances. So can we see this very interesting moment where Columbus seems to give the Indians the opportunity to speak. And then he says, anyone got a problem with that? No? Okay. No opposition? Okay, that's it, right? So can you see how he seems to give them the opportunity to speak, but speaks for them. And then we can see what happens when the Indians actually do speak. To the island which I found, I gave the name San Salvador. The Indians call it Guanahani. To the second, I gave the name Isla de Santa Maria de Concepcion, etc. But can we see that when the Indians are capable of speech, when they say, this is Guanahani, Columbus says, well, actually, from now on, it's going to be San Salvador. Can we see that? How, on one hand, there's this moment where they're given an opportunity to speak, and then they're, Columbus speaks for them. And on the other hand, when they do speak, that speech is, in a sense, erased, because there's a new sovereignty, and you can see the effects of language in these types of circumstances. There's a new sovereignty which has now been actually asserted against the Indians. Now, going back to Westphalia, I said the problem with the Westphalian model is it does not tell us about the whole question of imperialism. And so in the Westphalian model, the classical model of international law, there is a story about imperialism. And the story is something like this. And again, I'm being somewhat schematic, but the argument is something like this. Non-European people did not have sovereignty. And what happened over time was that sovereignty that was perfected in the West, all history takes place in the West after all. Sovereignty that takes place in the West is created in the West, is extended out to these benighted people who are lacking in sovereignty. And so this is what was justified in the 19th century and much earlier by a concept that I think we're all familiar with, the concept of the civilizing nation. They are backward, they are barbaric, and because they are backward and barbaric, they need our laws in order to be proper human beings or in order to be proper sovereign states. Can we see that issue? And so my argument, and this is a TWAIL argument, is that rather than see the problem of international law as being about equal and sovereign states, we might see international law as being about the whole issue of the civilizing mission. That international law continuously characterizes certain peoples, certain societies as being backward or barbaric or violent. And once they are characterized as backward or barbaric or violent, they are denied their rights. They don't have any legal status. And then the task of international law is to transform the backward or the barbaric or the violent. So this is what I call the dynamic of difference. That which is different is dangerous. It needs to be brought into the realm of the same. And perhaps that would be a different way of understanding international law. And it might be a way in which we can bring in the story of imperialism into our theorizing about international law. It's in those types of circumstances, 5 minutes, Penny says, that my claim is that we need to think of a different theory of international law based on the colonial experience. And my argument here is that imperialism is foundational. It is central to international law. I'm not saying that Westphalia is unimportant. Of course it is very important and it explains so much about international law. But it can't tell us really very much about the imperial experience and the ongoing effects of imperialism in these circumstances. Let me quote somebody else who I cannot put on the PowerPoint because it is a somewhat long quotation. So Penny, I'm going to have to ask for a little extension of time. And this is what the scholar says. The effects of apartheid have not disappeared with the stroke of the pen. nor will they simply vanish because of the enactment of new statutes. These effects are still manifesting. Like elsewhere in the continent, on attainment of political independence, gross disparities in social and economic terms are very much in evidence. The law and the structures set up to administrate have been the vehicle of oppression, and the administration of justice itself has not escaped the consequences of past mismanagement. This is Justice Paas Langa. This is from the essay he wrote for my teacher, Professor Veeramantri's Feshreef. And it is an essay called South Africa in the 21st Century, as I mentioned it. Now, I really don't have any foundation, any claim on which to comment on events in South Africa. As I said, well, for me, South Africa means many things, not just, Herschel Gibbs, very unfortunately. Brilliant, how could such a brilliant field, I mean, how could this happen? Anyway, so it's not just that, of course, that I think, of course, Nelson Mandela and inspiration that South Africa provides to many countries, also trying to go through transition. Like Sri Lanka now, at the moment, after a war. But the point is that, to go back to what Mr. Justice Langa says, and this is the same point that TWAIL scholars would argue, colonialism, in the traditional story, colonialism ended with independence. And so the United Nations brought about or assisted in the process of independence. And of course, South Africa plays a major story in that particular narrative as well, because the United Nations was so important in terms of asserting human rights, and the General Assembly wanted to impose sanctions and so forth as part of the whole campaign to bring about the end of apartheid. But the point that Mr. Justice Langa seems to be saying, and is the point I am taking from him in terms of the international system as a whole, is that perhaps colonialism did not end. Perhaps it simply changed its character. But the question then is, how do we formulate a set of concepts that would enable us to track that continuity? Can we see the issue? And my argument is that the Westphalian system does not allow us, does not have the conceptual vocabulary that would enable to trace the possible continuations of an imperial and colonial system. Now, just to close, finally, I've been visiting various countries. One of my interests is in the whole question about the teaching of international law. How do we teach international law? And one of the problems in many Asian countries is that international law is taught based on Western textbooks. And in those textbooks, the history of international law is entirely all these Western events. So scholars in Asia, for example, teachers in Asia were telling me, well, actually, we use those particular textbooks, and the events that are focused on are 1648. History is about dates, after all. 1648, or 1815, or 1919, or 1945. And I said, well, where does the history of your country fit into this particular narrative? And then he said something like, well, actually, it's not important because nothing of significance for international law happened in my country. That country was Vietnam. And it's possible to argue that one should actually think about the operation of international law, not just in terms of the heroic narrative, but also in terms of the dark side, where so many things that happened were justified by law. If we don't understand the dark side of this whole system, we will keep reproducing